Okay, we've given it a couple of minutes, so I think we'll get started. So again, I'll start all over from scratch again. My name is Paul Edwards. I'm with Local 770 as the Director of Training and Development. Today, joining us for this special webinar that our law firm, GEC Law, which is Gordon Edelstein, Crepac, and I forgot the last, the AWs, Monica. I tried to be fancy there.
It's okay.
Are here with us today are work comp attorneys who are based in both Los Angeles and the Tri-County areas that help our union members in regards to any issues and questions they have or potential injuries they have on the job. So Monica Farewell is with us today. She represents our members mostly in the Tri-County area, in Ventura County, Santa Barbara County, San Luis Obispo County, and most of our members may not be aware of it, but we also, Monica works directly out of our Camarillo office and holds regular hours to assist members with any workman's compensation questions and needs that they may have. So she actually, due to an outreach from our staff and our members, has agreed to come and do this webinar for us today to go over, I'll let her do her own introduction, but she will go over what she's planning to present today on general workman's compensation issues that we have, but also in the era of COVID. There's been a lot of changes in legislation and other issues regarding how your employer handles your situation around COVID and what you're entitled to. So she's going to engage us all in a very informative conversation today and fill us in on all the things we need to know. Before I turn it over to Monica, I'll just say really quickly, if anybody has any questions, we will answer them at the end of the webinar. Monica will take the questions at the very end, and there will be a significant amount of time for us to answer questions. So, but that being said, if you have a question 5 minutes into the webinar, it's okay for you to type that question into the Q&A that you have. If you're not on a telephone and you're actually calling in from a computer, there is a Q&A button at the bottom of your screen that you can type your questions in, and you can type them in at any time. And as I said, Monica will handle those questions at the end of the meeting today. And I think that's it. I'd like to introduce Monica Farewell.
Great, thank you, Paul. As Paul mentioned, my name is Monica Farewell, and I'm a workers' compensation attorney with GEC Law. He mentioned that I am in the Tri-Counties, and that's correct. I'm out of the Camarillo office. I originally was in the Los Angeles office, so I know about the Los Angeles rules and regulations as well. And however, we're here to help everyone. GEC Law is available all through Southern California, and we have many attorneys, and we'd be able to assist you with questions all throughout Southern California and beyond. Again, I wanted to let you know that we are a resource for you. It's a tough time right now. There's a lot of questions about COVID. There's a lot of questions just about leave in general. I'm going to cover all of that with you today. But we just want to make sure that one of the great things that your union provides is a relationship with different resources. And that's what we hope we can be, is a resource for you. Every day I connect with members and I discuss, the situations that they're going through regarding COVID or injuries. And I can help lead you to different attorneys, whether it's an employment attorney that you need to speak to or what have you. But just so you all know, I can be used as a resource. My firm is a resource to ask questions and get all of the information that you may need. I want to start off with discussing the information that you see every day in the news. I want to talk about COVID, and there's also a brand new California law that literally was just passed as of yesterday regarding a new leave policy for the state of California, and it affects everyone that's listening today, and I want to review that with you as well. First of all, as you know, COVID vaccines are ramping up and increasing every day, which is great. Hopefully, we can put COVID in the past. But one thing that many people aren't talking about are the symptoms that sometimes people are having with the vaccine or a bad reaction. Right now, it's really minimal. Apparently not that many people have a reaction. However, what I wanted to bring to your attention is, if as a frontline worker, if you receive the vaccine and were to have a bad reaction to it, there's an ongoing symptoms for days and days or even more. That's a reason to call my office and make sure that you talk to somebody, because as a frontline worker, if you get the vaccine to protect yourself from exposure to COVID, there's a possibility, that if you were to have a bad reaction to it, that you could be covered under workers' comp. There's a very similar scenario in healthcare workers, with healthcare workers. If they receive vaccines, for instance, for hepatitis B, and there's a bad reaction, then they can get covered. So this is all very new. The COVID information and COVID vaccines are very new. However, I can't imagine that it wouldn't be different, that it would be different for the frontline workers and a COVID vaccine. I believe that everyone has the contact information. Lisa is available to provide anyone that needs our contact information to any members that do not have it or would like the PowerPoint that I have created with the information, along with my direct email, the Camarillo office phone numbers, any of that, any way you need to contact me or my office, we can provide that, no problem. Let's see. Okay, great. So no questions so far. Okay. Next, I wanted to go ahead. Sorry.
Oh, sorry. No, that's a good point, Monica. As you transition into the rest of the presentation, just to let everybody know that this is being recorded as well. And what we'll do with this webinar is we will post it on our website tomorrow so that it's accessible to all of our members for a resource in the future. And it'll have all the other identifying information for your law firm and how to reach out to you as well.
Perfect. Great. And if you hang on till the end, if that's a question you have, I don't mind putting out into the chat or sharing my screen about all my information to take down as well. So I did want to jump over to and talk about COVID. Right now, we're over a year into the pandemic that we all went through, and obtaining or being exposed to COVID while on the job, that is a question of workers' comp and whether you are entitled to the benefits of workers' comp. Anytime that you have been exposed to COVID or you have lingering symptoms, that's definitely a reason to reach out to GEC Law, just to get, to know what your rights are, to know what can be provided through workers' comp. There is a overarching law that says if you have a work injury, you are sort of stuck in workers' comp. You have to file it through workers' comp. You don't have any other legal means to pursue a different type of case. So if you are injured on the job, if you believe you've been exposed to COVID on the job, workers' comp is where you have to go. Okay. If you were exposed to COVID or had COVID symptoms, especially early on, and you're not sure whether you were actually exposed, a good point to start is to find out from your own private care doctor to see maybe if you have the antibodies or if there's been any damage to your lungs. Okay. A lot of the doctors are reporting that whether somebody contracted COVID, whether they had lingering symptoms or were asymptomatic, there's a potential for there being damage to your lungs. Not everybody, but it's something that if you feel you may have been exposed, you want to check it out. Okay. And if you go to your own healthcare doctor and they say that, you know, there's possible scarring in your lungs, there's a reason that you may want to file a workers' comp claim, and we can talk you through that. There's also a new COVID policy that I'm going to go through in just a minute about taking leave now if you have been either exposed to COVID or if there's a family member that you are taking care of that needs to quarantine or you need to care for them. So if you are exposed to COVID now or have symptoms now, there is a means for you to request time off from work. The new law says up to 80 hours. So 2 weeks if you're a full-time worker, where you can take the time off to recover or to care for someone in your household that is suffering from COVID exposure. If you have been exposed to COVID and you are one of those long haulers that we see on the news, and you have continuing symptoms, it is definitely reasonable for you to discuss what rights you have through workers' comp. You may have all seen the news when the governor signed a workers' comp law for COVID, directly related to COVID. That law is a little complex, but it essentially does protect frontline workers when there is an outbreak of COVID in the workplace. And so if you want to ask questions about that law, whether you are someone that fits into that criteria, it's definitely a question you're going to want to ask an attorney. As I mentioned before, and as Paul mentioned, I'm a workers' comp attorney. GEC law, all we do is workers' comp cases. So this is what I do every day, and we'd be able to help you. There's also, of course, questions about, you know, how you go about filing a case for COVID, a workers' comp case for COVID. What are the steps? We can help you with that. COVID has changed the game in workers' comp, so to speak, because it's not like a slip and fall where you know for sure you fell at work, you report the injury, you file a claim. COVID is in the air. We don't know exactly when, the minute that you are exposed. And because of that, we're going to look at the circumstances. The judge would look at the circumstances of where you were. The specific law that the governor passed down sort of limits how much they can sort of question where you were, what you were doing. In my opinion, if you are a frontline worker and you believe you were exposed, you have a positive test from the past, then there's almost no question you're going to want to file for workers' compensation rights and benefits in order to be taken care of for free through the workers' compensation system. I wanted to just start and discuss the COVID leave policy. The new policy that was just passed and is effective as of yesterday, it is retroactive starting from January 1st of 2021. And it indicates that if you or a family member have a reason to take off of work to care for a loved one or for yourself because of COVID, then your employer, and it's employers with over 25 employees, which I believe would apply to all of you, then you can have full pay up to 80 hours, which can be up to 2 weeks. And that goes for both full-time and part-time workers. There's a calculation of how to pay a part-time worker. And if you're interested in knowing how much pay you would get while you're off of work as a part-time worker, call one of my office lines that will be available to you, and we'd be able to walk you through that. It's a little complicated, the math that they provided in this new leave policy, but it is available for both part-time and full-time workers. What's interesting is not only does the leave apply to caring for yourself or a loved one with COVID exposure, but also caring for your child if there, for instance, was an outbreak or exposure in a school or in a daycare center for which they shut down the daycare center or the school, and you have to stay home and care for your child. That is also covered, and I think that's very important to know. It also can cover a vaccine appointment. With the way the vaccine appointments have rolled out, it's very difficult to get an appointment at all. As of April 15th, all adults 16 and older can get the vaccine, and I'm hopeful that the process will be more streamlined and easy for everyone to have access to the vaccine. But if you only secured an appointment on a day that you are scheduled to work, you can request that day as part of this new COVID leave policy, and you could have that day paid for by your employer at full wages. Okay. I think that it's great that this extends the previous emergency leave policy and covers more just different scenarios that affects all of us, especially frontline workers. Now, I did want to discuss the basics of workers' comp and go through what to do if you do feel like you were exposed to COVID or outside of COVID. How do you file a workers' comp case? What do you do? What are the best practices on if you're injured at work? So first of all, to just give a background of what workers' compensation is, a long time ago in California's history, when they created the workers' compensation system, they decided it was going to be a no-fault system. That means it's not like a car accident case where they're going to determine that you were 50% at fault and only give you 50% of the benefits or 50% of the pay. Workers' compensation is no fault. The idea behind it is to get an injured worker the treatment and the benefits they need to get back to work. It has become a very convoluted process, but that is really what workers' compensation was created for, was to get the legal process out of the way, get the workers directly into a doctor or healthcare that they need, and return them to work. We try to do that and help people as best we can in promoting that process that they wanted a long time ago. If some of you have dealt with workers' comp, you know that there are a lot of delays, and it cannot be a wonderful system for everybody, but it does have its benefits. And we're going to go through a little bit of what you can do if you feel like you have been injured at work. The first thing to know is there are two types of work injuries. The first is a specific injury. If you have a slip and fall at the store, you know the date and time that you fell and say hurt your back. That is a specific event, and you know pretty much where you injured yourself and how, and you can report it right away. What's more tricky is what is called a continuous trauma claim, which sometimes you'll see as abbreviated as CT claim. That can be the repetitive stress and strain of a job, like repetitively stocking the shelves. That can, or repetitively checking out all of the products that you have to continuously move through the conveyor belt. That can cause, often I see it causing carpal tunnel syndrome. And it's one of those things that the continuous trauma claim is one of those things that you can sort of wake up and feel the pain. You don't really know where it comes from, but all of a sudden you just have a pain in your back that hasn't been there before. You have the pain, your wrists go numb and you don't know why. It's just something that you should ask yourself, do I feel like it's from the repetitive, 20 years of lifting the water jugs over the conveyor belt or what have you. And if it persists, it's something to ask an attorney about. If you just want to find out what's next, or how do I go about dealing with this? Is this something I have to file a workers' comp claim, or can I deal with it on my own? Those are the kinds of questions that I hear from members all the time, and that I answer, repetitively. Each case is different. Each person's ideas and what they want are different. And so that's what I deal with in helping you kind of, create a plan on what to do. So there are other kinds of exposures at work that are also under this realm of continuous trauma. And most people do not connect these types of injuries to a workers' comp or work injury at all. And it often is work related. Now, the threshold to being work related is 1%. All you have to have in workers' comp is 1% related to the job. So for instance, issues that come about like a stroke, hypertension, right, which is high blood pressure, diabetes. If there's an aggravation of diabetes because of the heavy job you have in the warehouse, that can be connected to work, especially if you see over a period of time your medication rising. There may be a reason for it. If you're under, more and more stress on your job, that might be what's causing an aggravation in your high blood pressure or any other underlying illness. Those aren't always connected as a regular workers' compensation case, but they are. For instance, if the janitors that I have represented over my time as an attorney, if they have the loud floor cleaning equipment and they're not provided with ear protection, the hearing loss is in part related to the job and can be claimed in a workers' compensation case. Other things to look out for is really like ongoing back symptoms, like I mentioned. Ongoing carpal tunnel that you have, ongoing knee problems that come about. And it's likely from standing all the time, if that's the kind of job that you have. There's also, if you have a work injury and you're taking ibuprofen and, a lot of it, and you start having stomach complaints, all of that is derived from a work injury and can be included on a workers' compensation case. The parameters for filing a work injury is 1 year from when you have a specific injury, right? 1 year from that slip and fall. 1 year when you cut yourself with glass. 1 year from when it's related to work. A continuous trauma claim is also 1 year, but it's 1 year from the date you realize it. If a doctor finally says, checking out all those heavy products, that's probably causing some of the back problem you have. And from that moment on, you may be deemed as you know what's going on. You realize that the back issue is from work, and you're going to want to talk to your manager or HR or an attorney about how to proceed and what are the next steps. What do you do now that someone's told you that the pain you're feeling is related to your job? And that's where we can help for sure. But once you do realize it, or if you do have that slip and fall or that back strain when lifting a box or what have you, the next step is reporting it, right? How do you report it to your employer? And this is really where it can get complicated in a case. You want to report it as soon as you know that you have injured yourself, whether that be telling your manager about, hey, I just lifted this heavy box and I feel a pull in my back. How we formally report a work injury is you file a form that's injury claim form, and that form gets sent off to the employer's workers' compensation carrier, similar to filing a car accident case. You call your insurance and you report it. Well, that's similar to what the store will do as soon as they receive the correct paperwork. Now, most people do not carry these workers' comp forms with them. The minute they feel some pain, they write it down and they turn it in, and all is well. Most people, if they feel pain or if they get a pinch in their back, they think, if tomorrow is your day off, I'm going to rest tomorrow. I'm going to see what happens. And then I will tell my manager, right? Well, you want to be careful. You do want to think about yourself and be cautious. It's always best if you do report a strain in your back and that you're going to try to rest during the weekend, you might want to send an email about it or text the manager if you have that sort of communication. That way there's some sort of written evidence along the way that you did feel the pain on that day. You want to try to rest first, and then you'll see what happens on Monday, right? Oftentimes in the cases, it can get a little messy where an injury wasn't reported right away. Then the question is, well, why didn't you report it? The common answer is most people do not, like I mentioned, carry around the reporting paperwork in their back pocket. And that's okay. You don't want to be that way. It's not designed for you. You can still report an injury even if it's been a little while. Most people wait to see how the pain forms, if it's going to get worse. If it gets better and you're back at work and you're 100%, then great. Then you did the right thing and you don't have to deal with more paperwork in the future. But a written response or a written report is always good to have to help you on your side later on. Some people are worried that their manager might get mad or upset that there's either a potential workers' comp claim or an actual, slip and fall and someone needs to go home. And that can happen. But it's still a good idea, instead of saying, never mind, let's not report it. I'll just go home and rest. To protect yourself, you're going to want to make sure it's in writing. You're going to want to make sure there's an email or, like I mentioned, a text message. If they offer you the paperwork, sign it, especially if you have to stop work for the whole day and go home to rest if it's been that bad of an injury. Or especially if you're taken to the clinic that day or you have to go to an emergency room, you're going to want to follow up and do the paperwork. And if you have any questions about whether your employer filed the right forms for you or what have you, we have those forms. We can provide them to you. We can help you send them directly to the insurance company for your store, and make sure that it is done properly and it's not just up to the manager to file it or not for you. As I mentioned, some people are worried about a manager getting upset or there being some kind of retaliatory response. In workers' comp, there is a law that says that no employer can retaliate against somebody for having a work injury. That can mean discriminating or cutting hours. If you have a work injury, you're off for a little while, you come back and you find that your full-time position has been made into a part-time position, that's a potential problem. And you can talk to us and we can help you. You're going to want to talk to HR, find out, if you can, the reasons for the change. Another great resource for all of you, as you know, is your union. You are protected by a union, which is so important, especially these days. You're going to want to ask your union as well how you became, a full-time worker one day and all of a sudden a part-time worker, and whether it has anything to do with the fact that you were out for a little while. Another question that I get all the time is, if I get injured at work, can they fire me? Can they fire me? Again, you are very lucky to have a union and to have specific rules about terminations. But the question of can they fire me? Well, they can fire anybody. The real question is whether that termination is lawful or unlawful. If you get injured performing some very dangerous activity, well, then they're probably allowed to terminate you. But you're going to want to talk to an attorney. You're going to want to talk to your union. But it's very rare where they are just allowed lawfully to terminate you while you're on leave for a work injury. In different panels that I do, I share the experience that I've had with different places, one of them being Rite Aid, which is not always a union location, but they had a policy where if you did not turn in a specific form, they just terminated you in the system. So I was receiving all kinds of complaints from clients that apparently one of the forms they sent her or sent many people, she didn't fill it out. They don't fill it out and they don't send it back. And they would just receive a FedEx package with their last paycheck inside and have no idea why they were terminated. They have fixed this now, most of it anyways, but it's a really bad idea for employers to just unilaterally terminate somebody while on leave on a work injury because they didn't fill out one of the papers that was sent to them. If anyone out there has had a workers' compensation claim, you get a lot of paperwork. It is very difficult to figure out which ones you fill out and send back, which ones are for your information only, and what have you. So that was a really bad policy that Rite Aid had, to just terminate people right off the bat if they didn't return a form. And in those instances, I connect those clients with an employment attorney to assist them on the next steps. In each case, Rite Aid apologized, returned the individuals back to their jobs, and paid them for the inconvenience. I also get a lot of questions about, if a stress case. People hear all the time about a stress claim. What is a stress claim? If you're stressed out about a job, a particular manager, a new area you've been moved to within a store, what do you do if you just need some time off? A stress case is also in workers' comp called a psych claim because it's mental for the most part. And you may have heard it be referred to as that. Those cases have particular rules and laws that are very complicated. If you are experiencing a new and stressful situation and you want some time to step away from that, it's a good idea to contact us and have us explain to you what the rules are and why it may be a good idea for you to pursue workers' comp or not so good of an idea to pursue workers' comp at this time. With a stress claim, the insurance company can investigate all the details of your life, essentially, any other stressors in your life, whether it be financial stress, marital stress, any stressful situations in your past. And that can be very uncomfortable. So that's why that's very different than other workers' compensation cases. If you injure your back at work, the insurance company cannot ask you if you have marital problems. But they can if you say, I'm stressed out and the stress is only from work. They can ask if you have other stress and where is it coming from. And so these are the kinds of questions that I field all the time, and we can help you with that. Sometimes you're better off only going to your private doctor and getting taken off for a little while to lower your stress and anxiety on a non-workers' comp basis. And that's oftentimes the way to go, so that not all of your information is out there for the insurance company to ask you about. So you have an injury at work, you know about it, you've reported it, and it's been filed. What happens next, right? The insurance company, once they've received that injury claim form I mentioned, they have 90 days to decide whether they are going to accept your case or deny your case. And what that means is an accepted case means, if you have a slip and fall and you injure your lower back, they accept liability or responsibility for your lower back. They are going to pay for the medical treatment. Every single store and their insurance company has a list of doctors. You do not need to stay in the clinics that they initially send you to. Most of those clinics, especially if they are called US HealthWorks or now Concentra, they are doctors that are not always looking out for your best interests. And I was not aware of that until I went into workers' comp, that every doctor is not created equal. And the medical treatment that they provide is not always the best. So if you need help with switching to a different doctor that's on the list, please know that there is a list for every case. If your case is accepted within workers' comp and you want to get away from the clinics. Most of the stores that I represent, SCOE or Southern California Orthopedic Institute, they are on the list. UCLA, they provide really good health care to everyone, and they can likely help you and assess your injury better than one of those clinic doctors. So once a case is accepted, they provide medical treatment. They provide you with temporary disability, which is similar to state disability, which means it's a benefit payment to you while you are recovering for an injury. And a doctor must certify you to be off of work. And that doctor will then tell the insurance company to pay you benefits because they have taken you off of the job. Workers' comp, when they accept your injury, will also pay you at the end of your case something called permanent disability, which is the term of art in workers' comp to say that this injury has had lingering symptoms to you for a while, such that you're still experiencing them. Or if you have to get a surgery, even though your shoulder, if you have shoulder surgery, it may feel great. It may feel better than it did before, but you still have a permanent change in your shoulder that you didn't have before the injury. And you will get compensated for that. The last thing that workers' comp will provide are accommodations. If you need temporary accommodations because of the work injury, then the doctor will write that down, and you can turn it into your employer and they can see if they can accommodate you. If your case gets denied, a denied case means that it's almost like you're locked out of workers' comp for the moment. And you need to proceed as if you were hurt at home. If you have a denied case and you are out of work, if your own doctor has taken you out or you are too hurt or sick to return to work, you should apply for state disability. State disability is provided through EDD, the Employment Development Department. And they also provide unemployment. You are going to want to select the box that says State Disability Insurance, SDI. That often gets confused with Social Security Disability Insurance. So Social Security is the federal program, and Social Security disability is what you apply for if you do not believe you will likely be returning to the workforce at all. It can be a temporary situation, or if it's a bad enough injury and it's unlikely you will ever be returning to the workforce, that's when you file for Social Security disability. Very different from the state system, from the California State Disability Insurance, which is a temporary 1-year payment plan that will provide you with 2/3 of your wages, just like workers' comp's temporary disability. It will provide you with 2/3 of your wages while you were recovering from an injury. When your case is denied, you will have to get treatment from your own doctor through your own insurance. And often when your hours are required in order to continue with your health care, a denied case really starts the clock ticking. The minute you know about your case and it gets denied, you're going to want to talk to somebody because you don't want all of your benefits to run out, your health care to run out. It can be quite difficult if I get a case after everything's been denied, your health care's been cut off, and there's no money coming in. I'm going to want to immediately have you file for all these different things and have you see a doctor. And it just gets more complicated the longer it goes on. So you're going to want to talk to somebody if that's the situation that you're in or have been in. What we do in that situation, some stores are involved in the collective bargaining agreement, and we go, if your case is denied, and we make sure that we send you to an evaluating doctor in order to determine whether the injury you're claiming is related to the job. And you're going to want to know that and talk to somebody so that we can, if your case is denied, we get that appointment set up sooner rather than later. Like I said, you really don't want to wait. Most of the time, especially with a denied case, most of the time you're going to want to at least speak to an attorney. The insurance companies know that the attorneys know the rules and that you don't. So that's why we're going to want to make sure that we help you out with, the specific times to get treatment approved, or the specific things they have to do in order to set up that evaluating doctor to determine whether it's related to work. All of these things, all of the GEC law attorneys can help you with. And those are really the basics of what to do when you have a claim, and kind of a little bit of what happens after. There is 15 minutes left, and I really want to open it up to any questions people have. So, Paul.
So we do have a couple of questions. So this would be the time. We have 2 questions in the chat, in the Q&A, that we'll get to right now. And then if anybody has any other questions. I noticed that there are a lot of our field staff are on this call for information as well on this webinar. So any field staff that may have any questions that they want to put in the Q&A that will help assist our members, feel free to do that as well. So, but Monica, do you want me to read the questions off to you, or do you have them available to you?
I have them available. And so
Okay.
let me just start with this. A really good question. The first question is really good. It says, if you've already been paid for COVID already, can you still get paid if you have a bad reaction to the vaccine? So often, as it happens with the legal profession, the answer is it depends, right? They have said that if an employer has covered somebody for the 2 weeks already, that and again, that's full pay. If you were off and you received half pay or less than full pay, then you still have some money owed to you. But your employer can determine whether they want to use that. Say it was 2 weeks that they paid you already. If they want to use that time that they paid you between January 1st up until yesterday as your COVID leave, if it was before January 1st, well, then you now have another 2 weeks provided to you. And that's when you can, it says by written warning or by written or verbal response to your employer, you can ask for the time off and they must provide it to you full pay. The other question, so it's talking about a termination and a specific that this person has a case. So with anything that's case specific, I'm going to want to talk to you off of this panel, but whether they can terminate you, that's a really good question, right? As I mentioned, they can do anything. Whether it was lawful or unlawful is the biggest question, right? And I can assist you and anyone else with this issue with referring to an employment attorney. And if it was at all related to the workers' compensation injury, right? If there's a smoking gun that says we're going to fire so-and-so because he got hurt, there's a way in workers' comp to file an added claim to get additional benefits. So you're going to want to talk to one of my attorneys in my office. How taking sick leave or vacation time, the new leave law says that's not good enough, that employers cannot dock you for your pay, meaning not even use vacation time or sick time. Okay. This needs to be a whole new leave that's just paid for by the employer, meaning the 2 weeks doesn't come out of your sick time, sick bank, and the leave doesn't come out of your vacation time. Now, they can retroactively pay you back that time and say those were the 2 weeks that you're covered. Most likely, I mean, this is brand new. It came out yesterday, so I don't have every answer, but I think most likely they're going to say if anything happens to you in the future, you have 2 weeks off. And this law is up September 30th of 2021, unless it gets extended. So what you want to do is, if you don't believe you're going to be off another 2 weeks or need to take care of somebody, you can claim the 2 weeks or any time less than 2 weeks that you were off and get the sicker vacation time back in the bank. That's what I would ask HR to do and see kind of how they want to proceed with that. So if I was vaccinated on my own time, can I still be paid? All right, hold on one second. Okay. So so it says, as far as workers' comp, this new leave policy doesn't really interact with workers' comp. And if you were off for COVID, you could potentially claim 2 weeks, but either way, because workers' comp, if you're paid during a period of time, the insurance company doesn't have to pay you. So if you were receiving temporary disability, you could get 2 weeks of full wages, but in my opinion, you would want to wait and see if you have, once you've been released off of temporary disability, if you have some time to take off. I was vaccinated on my own time. Can I still be paid? So that's one of the criteria. If it was between January 1st of 2021 and you took sick leave, if it was after January 1, you can definitely let HR know that you took this time off, that you want it covered under the new leave law and get paid for that day. Everyone is figuring out this new law and we can help you with that. But I would start with HR first. They're going to be the ones figuring this out specifically for, each store and each location. And it's also something to mention to your union as soon as they have a chance to learn this as well. So then the next question is, someone has been on sick leave because of sciatica, and you've been with the company for 33 years, standing for 12 hours most of the time. Are you a candidate for workers' comp? And again, it depends, but that's often what I see happen. I'm sure you didn't just stand. I'm sure you also lifted and moved things and pushed and pulled. And it's definitely something to speak to a workers' comp attorney about. And then if your sick days are exhausted, then yes. So you're going to want to do two things. If you don't feel like you can return to the job, you're going to want to file for state disability, because that's the first route to go on, so that you have some income coming in. You're also, if you feel you're now out of a job because of an injury that you can connect to work, you're going to want to talk to a workers' comp attorney about how to file a claim. And since this is something they'd likely deny, you're going to, and the funds are running out, so to speak, you're going to want to do it faster than someone else that's still working. If you got vaccine on your day off, do I still get paid? Probably not. The way that it's mentioned is, if you need to take the day off to do the vaccine and you were supposed to be working at that time. That's my understanding of it right now. And so going forward, anyone who hasn't been vaccinated can request the day paid off.
I think that covered those questions.
Great.
All right, thanks, Monica. I know that a few people, so there's two things. One of the questions was asked by one of our union reps. I'm not sure if she received the chat privately, but it was a continuation of that first question as it related to work comp. So that question can be handled offline, because there's more questions to that gets a little bit more complicated, and it's hard to do it in a chat. So Lori, we can take that question later. Monica can talk to you directly about that particular case. But I also, yeah,
sorry, Paul. Just so everyone knows, talking to me and my time, it's completely free. It's free to you. Some attorneys' offices you hear about, you have to pay. I spend as much time as you need to go through the issues and let you know what is best for you. Right? Not everyone wants to file a claim. It's not time for everyone. Some people just need their questions answered, and that is why we're here. That is why your union trusts us to help you out.
Great, exactly. I appreciate that. So with the last few minutes that we have as well, we do have a couple of people that called in that aren't able to put a question in the Q&A. I don't know if any of our callers have a question. If you do, you can hit *9, and by hitting *9 on your phone, it'll allow you the opportunity to ask a question. So do any of our callers have any questions? And I'll give you a minute to do that if you do.
So that
don't.
newest question that just popped up that says
Uh-huh.
there was a member injured at work, took time off of work, returned to work for 2 months, and then the new doctor took them off of work. If that, can you reopen the claim? So the claim shouldn't have been closed if it's that new. They don't close them on their own. If it's a very, very old injury, that's a question to call my office and talk about. Claims can be reopened within 5 years. If a doctor is saying this is a re-aggravation from a 10-year-old injury, that may be, or it may be a completely new claim and new injury, and filing a new injury would allow the worker to be provided with workers' comp benefits versus a 10-year-old injury.
Perfect. Okay, very good. Any other questions from anybody before we wrap up here? We are doing a Spanish version of this webinar. That's why Al from Al's last name is not Gekla, but Al Lazaria has joined us as well, who will be doing the Spanish version on a different call-in line. And so you want to say hi to everybody, Al? You've talked to some of these folks before in our office that are on this meeting right now, this webinar.
Hi, Paul. Hi, Lisa. Hi, Monica. Hi, everyone.
Hi there.
So I'm excited to do this for you guys. Whenever you guys are ready.
We appreciate it. We appreciate it. All right. So I don't see any other questions. So we will wrap up the English version of this. I'd like to thank Monica very much for coming on and taking the time. It was actually Monica's suggestion to do this, not ours. She had gotten some outreach from some of our staff and in dealing with our members and thought it would be a good idea to present this information again today. So we appreciate you being so thoughtful about reaching out to us and giving the updated information on COVID and general work comp information to our members today. We appreciate your time.
No problem. Thank you for letting me be here.
Just a reminder, we will create a link and we will send it to everybody that participated. And even for those members who didn't participate, we'll do that splash page where we get a recording of this full recording of Monica's webinar. She has a PowerPoint presentation of what she discussed in a written form, and then all the resources and phone numbers you'll need. And then you guys know where to find me if you ever have any other questions, but that should be sent out tomorrow.
Great, thanks, Lisa. Monica, do you have any wrap up that you'd like to do on this? Or?
Yeah, so I'm sorry I had to go fast. There's a lot of information, and you can see each person and each situation is different and really can be tailored to each individual situation. And that's why we're here. We're here to let you know the general and information, but we can really discuss the specifics with you personally.
Great. Thank you, everybody, again. And we will be talking to you soon.
Thank you.